Welcome to this explainer. Today we are diving into something incredibly fascinating, the newly reformed CLAT PG exam format. If you've been following the legal education landscape at all, you already know this test has undergone just a massive transformation. We're going to look at the actual sample questions released by the committee to see exactly how this new format challenges candidates to think. We're literally going to peel back the curtain, look at the actual mechanics of these questions, and figure out what it truly takes to succeed on this reformed legal battlefield. Okay, so here's our roadmap for today. We'll be looking at the overall shift in testing, diving into the legal knowledge MCQs, tackling those tricky written problems, and wrapping up with exactly what is being tested. Section 1, a shift in testing, the new era of evaluation. Think about the old days of legal exams. They often relied entirely on rote memorization, right? You were rewarded for acting like a human encyclopedia, recalling specific case names or knowing the exact year a very specific statute was passed. But the new era, the committee just isn't interested in that anymore. Instead, they want to see logical application, structured legal reasoning, and your ability to solve complex mini-puzzles. It's really all about applied deductive reasoning now. Section 2, Legal Knowledge MCQs. Let's look at some real sample questions. In our first sample, the topic is the Indian Contract Act of 1872. But here is the massive twist. You're actually provided the exact text of Section 27 right up front. The core concept that agreements restraining trade are void is given directly to you. You literally don't have to pull this definition out of thin air. It is right there on the page. But giving you the rule, that's just the setup. Here's the actual question. Does a separate common law rule allowing lawsuits for inducing a contract breach conflict with Section 27? So the absolutely crucial point here is that you aren't recalling case law from memory to answer this. You are being forced to reason through whether these two specific legal ideas, a statutory rule against trade restraint and a common law rule about inducing a breach, can logically coexist. Our second sample deals with adverse possession. And again, the exam provides the basic doctrine right out of the gate, that someone can gain ownership of land by treating it as their own, openly, for a long enough time. The test supplies the relevant legal text before you even start. Now, the really interesting part is what you're asked to do with that definition. Can a tenant who overstays their lease use the doctrine of adverse possession to claim ownership? You're asked to logically apply that given rule to a brand new scenario. It acts as a complete mini legal reasoning puzzle. You don't need to recall a specific case name, you just need to deeply understand the underlying mechanics of the doctrine and apply it to a tenant-landlord dynamic. Section 3, tackling written problems, or as I like to call them, the elaborate hypotheticals. These written problems are all about navigating incredibly messy, multi-part facts. The committee provided 2 full sample problems in their report, and I have to say, they give us a very strong sense of the sheer complexity and depth expected from candidates. Let's break them down. Let's untangle the first sample. This is a constitutional law hypothetical set in a fictional country called Darshanya, which essentially acts as a stand-in for India. First, Darshanya passes a controversial electoral funding law allowing anonymous political donations via bank-issued certificates. Second, this law exempts these big anonymous donations from the usual corporate caps, and it's pushed through as a money bill, which conveniently limits the upper house's role. Third, a court steps in and strikes parts of it down as unconstitutional, citing free speech, voter information, and unreasonableness grounds, while also questioning that money bill classification. It is a wildly dense, layered fact pattern. And here is where it gets incredibly challenging. As the test taker, you're thrust right into the hot seat. You are presented with 3 specific entities: a losing candidate, a company that donated to both major parties, and the election commission. Your task? You have to impartially advise every single one of them on their specific legal positions and their possible remedies before the Supreme Court. You have to pivot your perspective 3 distinct times within the exact same messy reality. Moving on to the second written sample, honestly, this one is an absolute international law nightmare regarding a climate treaty. Mapping out the actors really helps us see the breakdown here. We have 4 or 5 countries interacting. Countries 1 and 2 attach side statements narrowing their responsibility. Country 3 objects. Then, Country 4 suspends its commitments, citing a natural disaster emergency. In retaliation, another country responds by suspending its own commitments in protest. It's basically a domino effect of international legal actions. Based on that chaotic climate treaty, you're then tasked with answering these 3 linked questions. What effect do those side statements actually have on the treaty obligations? Does the first country's disaster suspension constitute a breach of the treaty? And finally, does the retaliatory suspension breach the treaty? You have to weave through complex international law principles to determine who is actually at fault. Section 4. What exactly is tested? Let's look at the grading rubric. The report explicitly outlines the core philosophy of what they are grading you on. First, structured legal reasoning. Second, correctly identifying the relevant legal principles hidden within the text. Third, the methodical application of those rules to the messy, multi-part facts we just looked at. And finally, clear writing. Oh, and the kicker? You must achieve all of this within a strict limit of roughly 600 words. No pressure, right? To succeed in the written section and hit that clear writing benchmark, you absolutely have to follow this exact formula. Step 1, state your answer up front. No beating around the bush. Step 2, give your supporting reasons clearly and logically. Step 3, explicitly address counter-arguments to show you see the whole picture. Interestingly, the source notes that this strict, structured essay writing standard is the exact same one proposed for the undergraduate essay component as well. Structure is literally everything. Which brings us to our final thought. We've seen this massive shift from rote memorization to complex applied logic. We've explored the mini puzzles in the MCQs and the massive multi-layered written hypotheticals. It's a fundamental shift in evaluating legal minds, testing not what you have memorized, but how dynamically you can think. So, armed with the rules of this new era of logical deduction, how would you fare on this reformed legal battlefield? Do you have the structured reasoning skills to crack these puzzles yourself? It's certainly a fascinating challenge to ponder. Thanks for joining me on this explainer, and keep exploring.